session.
Thank you, Ms. Kraft, and on behalf of Judge Bennett and Judge Golden, I am pleased to welcome counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were in the courtroom together, and each of you has 15 minutes, and I understand the appellant has reserved some time for rebuttal. With there being no announcements, Ms. Kraft, please call the case.
Carolyn Harrill versus PI Tennessee, LLC, et al.
All right, you have the floor.
Thank you, Your Honor. May it please the court. My name is Tony Graffio, and I represent Carolyn Harrill. I would like to reserve 3 minutes of my time for rebuttal.
Very good.
Thank you. Now, the case arises out of a vicious dog attack on Ms. Harrill that took place at Brandywine Estates, which is a trailer park where a trailer was located on lot 31. This is important because the resident of lot 31, her son, owned a dog named Ruger, which was a pit bull.
Who owned the mobile home?
Gina Branch owned the mobile home.
Okay.
She leased the space, lot 31, from Brandywine, the landlord. Mr. Pitts, her son, had also signed that lease and did from time to time live there and did in fact have the pit bull there prior to the occasion that it attacked Ms. Harrill. The trial court heard summary judgment and granted summary judgment for the landlord and found that there was no legal duty upon the landlord as of the date of this attack. And the crux of the finding there was that the landlord had no actual knowledge that Ruger the pit bull was at the trailer on the day of the attack on Ms. Harrill. We have argued in our briefs and at the trial court level that foreseeability here must also look at the foreseeability of Ruger returning to the property. And in order to get there, we have to go several weeks back to what Brandywine, the landlord, knew about Ruger's owner, and Gina Branch, the resident of the trailer. We go back to early January 2018, several weeks before my client was attacked. This same dog in this same trailer attacked a lady named Madison McGill. The landlord very quickly, this is undisputed, learned of this attack. Ms. Branch was under this lease that had a pet policy. The pet policy very explicitly says no pit bulls. No pit bulls in the trailer by a visitor or any other means, or certainly not to have one there as a pet. So what did Brandywine know and when did they know it? If we're looking at the foreseeability of harm, the gravity of that harm, and we're weighing it against the alternative conduct that we're asking this landlord to engage in, what's the analysis? Well, first of all, as of the date that the landlord knew about Ruger biting Madison McGill, they knew that there was a vicious dog on their property in that trailer that had bitten a human being. Armed with that knowledge,
did they know the dog was in the trailer that day?
They found out about it the day it bit Madison McGill. Yes, sir. Yes, Your Honor.
So that was the first. That was the first incident.
They thought. Right.
Right. This was several weeks.
The dog had been removed. Right.
They were led to believe that Pitts had brought the dog to a friend's house.
Okay.
Now
and they had no reason to know that dog was hidden in the trailer.
They did have reason not to trust these folks about the pet policy because of their history. And if we look at all of those circumstances, we're led to the conclusion that there's a question of fact about whether or not the landlord did enough when they learned about Madison McGill. Was it just enough to say, hey, this dog can't come back, when they knew they were dealing with two individuals who had no regard for this pet policy. Why did they know that? In 2016, the very same resident, Miss Gina Branch, got in trouble for having a pit bull in her trailer. She was told at that time in writing.
If the dog is in the mobile home, how is the mobile the facility here, how is it supposed to know?
Well, that's what the trial judge said. There had to be actual knowledge, and the foreseeability analysis takes more than that into account. In any kind of premises liability case, the landlord is on notice of a dangerous condition. It's a dangerous dog who's bitten a human being.
But it's in that dangerous condition is in a building the landlord can't have access to.
Well, the landlord did have the ability to get Branch off, to oust Branch from the facility, and decided to do that. But it was too little too late. They took this long route to do that. If they had simply said, enough's enough, you're out of here, which they were allowed to do under the lease, this never happens. It doesn't become an issue of how are we going to know if the dog comes back. It's a fact that they know the dog was there, violating the policy, and they failed to take steps which they were allowed to take under this lease to get rid of the root problem, which is Gina Branch.
Based on Mrs. Porter's affidavit, that avenue would have cost them a considerable amount of money that they might not get back.
Your Honor, that's a great point.
Thank you.
The Eleanor Porter affidavit, however, was based on rank speculation. She had never tried to do it.
Well, there's a lot of rank speculation in this case, I think, from both sides.
Well, taking everything in the light most favorable to the plaintiff, however, at the summary judgment stage, we were simply asking for a jury to help us sort all that out, Your Honor. Of course, there are many issues, some of which Ms. Porter brings up about feasibility. Feasibility also works its way into the duty analysis. And the fact that the judge did, in fact, consider that affidavit as part of his decision was an abuse of discretion, because Ms. Porter was speculating about all kinds of things, the cost, the amount of time, when she actually had a lease in her hands that allowed her to get Ms. Branch out of there, but she never did that.
So in other words, you're objecting to the fact that Mrs. Harrill immediately took action by entering into a formal legal eviction process? Is that?
I do. I say with this particular resident, Your Honor, that was not enough. Ms. Porter, the owner, said in her deposition, once I initiate eviction, Ms. Branch could do whatever she wanted to. I had no control over the situation. So she ceded control for over 80 days to a resident who she knew she could not trust, who had this vicious dog in her life directly through her son. And his
did the dog, was the dog there when Ms. Harrill arrived to help clean out the trailer?
The dog was
or
there.
Did it arrive with her?
It actually was with Mr. Pitts.
And did they arrive together?
No, Your Honor. I believe they arrived separately. She came to try to help with the cleaning out of the trailer, which is ironic. And again, there's no question that there's plenty of facts to be sorted out in a trial before a jury. But to take that away from the jury on the duty issue, we argue was a step too far. If you look at the Dion versus Brown case, and granted, this is not factually identical, but it's very similar. In Dion, a dog had bitten a maintenance man, and the landlord found out about it. In that case, the landlord really did nothing. Of course, we're arguing that what the Brandywine folks did was too little under the circumstances. But the important principle in Dion is this, what they call a moral blame. where the landlord stands aside and allows the opportunity, the risk, the dangerous condition to remain, there is moral blame to do something about it if the lease provides a mechanism. That's exactly what was going on here. So the same principle applies. There is a moral responsibility upon Brandywine to recognize they are leasing this spot to a person who cannot be trusted to simply keep the dog away for the next month, 2 months, 3 months down the road while we handle an eviction. And under those, yes, sir.
The lease did provide an alternate, almost immediate eviction option, but was that a realistic option that you could just go in and toss somebody out of, have their trailer hauled off without any legal authority, without any court intervention?
Well, we do know that the lease provided for it, Your Honor, but we won't ever know the outcome because they never tried. Ms. Porter admitted, we've never tried to do that. Oh yeah, all that's in there, but we've never tried it. So, Your Honor, I would like to know more about that in the course of trying the case to a jury and let a jury decide whether or not it was feasible. I think that's a fair question, but it's a question of fact. And I believe
in this case, this case is not subject to the Landlord-Tenant Act. Is that correct?
Well, it is an interesting situation because she owns the trailer. In fact, Your Honor,
But she's renting the lot.
she's renting the lot, but somehow she was eventually evicted from the trailer and Brandywine kept the trailer. So it's an interesting concept that they've got going on there. But at the time of the dog attack, Miss Branch actually owned the trailer.
Interesting.
Yes, sir. So that is, I actually ended up touching on the affidavit issue as well. So that's the end of my time. I did reserve 3 minutes for rebuttal.
All right. We'll hear from you more on rebuttal. We'll hear from the appellee now.
Good morning, Your Honors. This is Austin Wareheim. I represent Brandywine Estates. May it please the court. The appellant in their argument addressed 2 questions. They suggested that the questions that were important here are, what did they know? Meaning, what did Brandywine know? And when did they know it? I submit to you that there is a third question that is even more crucial, and that is, what did Brandywine do with the knowledge that they had? It's undisputed that we knew that Ruger had bit someone on lot 31 on or before January 10th of 2018. It's undisputed that we then took action to ask that the dog be removed, and that we were able to confirm that the dog was off the property on January 10th, 2018. 21 days later is when Miss Harrill was bitten. During that time, we had started a 30-day eviction process. Brandywine started a 30-day eviction process. 9 days short of that 30-day eviction process is when Miss Harrill was bitten. In order to place a duty onto a landlord for a dog bite that takes place on the landlord's property, there needs to be knowledge or notice of the vicious propensity of the dog. There also needs to be a sufficient retained control over the leased premise to afford an opportunity of the landlord to require that the tenant remove the dog, or that the landlord themselves safely restrain the animal. Both of those prongs are not met in this case, and that is why the trial court granted our client summary judgment in this case. The first portion, knowledge or notice of the dog with vicious propensity. Sure, we had knowledge that there was being crucial, a dog with vicious propensity on the property. However, we removed the dog. It's undisputed that the dog left the property, at least for a period of time, and we had no knowledge of the dog's return, and we had no way of discovering that the dog had returned because as Judge Bennett indicated, it was inside of the trailer. And as it's undisputed that that trailer was owned by the tenant at that time. In order to get inside that trailer, we'd have to have some sort of warrant, and we'd have to go through the legal system. And we'd have to have a continuing warrant to monitor the inside of that home. And that's honestly unfeasible. And I don't think this court would want to send us down a path where landlords are required to get warrants to search the homes of their tenants. Second, there has to be a sufficient retained control over the leased premise to afford an opportunity for the landlord to require the tenant to remove the dog or safely restrain it. Well, we did this, actually. We met this problem. We removed the dog, and we were able to verify so. It's even undisputed that we monitored for Mr. Pitt's truck and for the dog to return to the property, and they were never seen or detected. The dog apparently somehow ended up inside of the home, and Miss Harrill went in the home and was bitten during the time that we were attempting to evict this tenant. On the notion of constructive notice and the theory that appellant is proceeding under is the common occurrence theory. That is a pattern of conduct or a recurring incident of general continuing condition. It's undisputed that Ms. Branch did violate the terms of her lease, including the pit bull portion of the lease. That occurred in 2016. That was remedied. There was not another violation of that particular portion of the lease until the January 10th dog bite 2 years later. And the dog that was on the property at the time was not even her dog. It was her son's dog, Mr. Pitt's dog, which is Ruger. Now, sure, we had some trouble with this tenant, but we also have to be aware and separate out who we're talking about, who the party was that brought the dog onto the premises. It was Mr. Pitt's. It was the son. To insinuate that Miss Branch's repeated violations somehow gave us a constructive notice that she was going to continue to invite her son to bring another dog after 2 years of actually adhering to that portion of the lease would be a wildly different violation than what she had previously committed. And as to the affidavit issue, the affidavit really, despite if it's admissible or not, it really falls away because the trial court, in their order, never once relied on any of the information in the affidavit in citing the undisputed facts and the facts that they decided this case under. If you look on the trial court's order in the technical record on page 232, volume 2, and volume 2, page 233, those are the facts that the trial court granted summary judgment under. Those facts are quite simply that we did not have notice of the dog's return and that we had met any duty that we had to this particular plaintiff by removing the dog on January 10th and monitoring for such. You will see that the citations to those undisputed facts never once cite the affidavit. Instead, they cite the statement of undisputed facts, which we submitted, and the responses that were given by the plaintiff. They're simply what the parties agreed to the facts being at the time that the motion for summary judgment was argued. And so even if this affidavit was inadmissible, it wouldn't matter. But the affidavit is admissible. The two tenets that were cited as for the affidavit not being admissible were rules 701 and 702, which deal with lay witness testimony and expert witness testimony. This is really neither. This is a business person who cited some facts that she set up a monitoring system and that the dog was never showed back up on the property. it also goes into the expense of removing someone's mobile home from a mobile home park. Those are facts that she has from being in the business. It doesn't require an expert to tell you what a business owner knows it costs for them to do something. And so it's wholeheartedly admissible. And in the trial court's order, they cited Rule 701 and 702 and stated they felt that this affidavit was admissible. So it was admissible and it should have been considered, and it was rightfully considered when this order was crafted. Your Honors, this case is just a simple dog bite case. It's nothing more than that. What the appellant is asking today is for this court to institute an alternative standard of care, which would require landlords in this situation to subvert the legal process and immediately evict someone without notice. Currently, I have cases where we're trying to evict squatters. You have to go through the legal process to get someone out of a home who has no legal right to be in the home. The sheriff will not evict them without a court order to do so. It would be imprudent to require a landlord after one dog bite to completely upend someone's life and remove them from a home or from a trailer park of some sort, towing their property away while they're in it maybe, without going through the legal process. That is what the appellant is asking you to do here today. And I would submit that that's just unreasonable. It's not what the law says needs to be done. The law requires us to remove the dog with dangerous propensities. We did so. We have met the obligations. There is no duty to this particular plaintiff at the time on January 31st of 2018 when this bite occurred. And thus, this court should uphold the trial court's granting of summary judgment. With that, I yield my time. And if you have any questions, I'd be happy to answer them.
Thank you, Mr. Wareheim. We'll now hear the rebuttal. Be sure to unmute.
Sorry about that.
Not a problem. It's a free service we provide. So,
Well, I will say this supposed alternative standard of care is taken from the landlord's lease. It's not something we just invented out of thin air. It does seem appropriate under these circumstances for Brandywine to have at least attempted to invoke the faster, more efficient way to eliminate the root problem, which was to get these two individuals out of their life. And Ms. Porter admitted that's exactly what she was trying to do. We argue she just took the long route when she could have at least attempted the shorter route. Had she been successful and they had left, the dog would not have been there. My client would not have been there. This would have never happened. Also, as far as the idea that actual knowledge is always required here to hold the landlord liable for a dog bite, if we take that to its logical conclusion, this Ruger or any other pit bull could have shown up every single day unnoticed by the landlord, bitten a new person, and then the landlord finds out and says, wait a minute, you know the rules, get Ruger out of here, get that new pit bull out of here. It's absurd. If that's really what we're going to allow here for however much longer this resident is going to stick around and cause trouble, Ms. Porter says, my hands are tied. There's nothing I can do about it. Well, your lease says otherwise. And that's what we want a jury to determine. Did the landlord do enough under these circumstances with these individuals who could not follow this pet policy and had shown that by their past conduct? If we weigh the foreseeability of that dog returning and the gravity of harm, which unfortunately we now know precisely the gravity of that harm, against the burden of the alternative conduct, the Dion case clearly speaks to this. They say The burden here is to lose a tenant. Brandywine had already decided to lose this tenant. Ms. Porter was looking forward to losing this particular tenant. So there was no burden, really, no undue burden when compared against the gravity of the harm, which unfortunately my client did suffer. Thank you very much.
Thank you, Mr. Graffio and Mr. Wareheim, for your arguments. We will take this matter under advisement. Ms. Kraft.
This Honorable Court of Tennessee is